All right, good peeps, let's make this happen. Shaw versus Reno. Now, this one we kind of touched on a bit before in class, and it has everything to do with that G word that I told you, and which we discussed in class several times over. The G word is gerrymandering. So let's get directly into this bad boy in regards of Shaw v. Reno. All right, I'm gonna quickly go over the terms and vocabularies. You can watch this later on and replay this. But first key term in vocabulary is the concept of gerrymandering, right? The act of dividing an area or district in in a usual way to give a certain group an advantage or disadvantage, right? Divide this bad boy up into slices or in different angles to give a particular side an advantage or disadvantage one way or the other. Next concept is the 14th Amendment. I know I talked about the 14th Amendment over and over and over and over again. Oh, by the way, did I mention over again? I probably did. So I know I talked about it so many times that it becomes repetitive for you all. I get it. I understand. But you'll be okay. Definition, equal protection clause. You'll read the rest overall. Now, with that in mind, let's get directly into this concept about the historical backgrounds that's taking place regarding Reno versus Shaw. Now, when after 1990 census, the North Carolina General Assembly withdrew its congressional districts to account for changes in population. Remember, every 10 years, the census, i.e., the census is supposed to happen now. Now everything is online. That information in regards of the census is predicated on how many people do it. It is mandatory that we do it. But more importantly than that, is to figure out what is the population of the United States. And more importantly, will the state either contract districts, expand districts, or redraw the lines proportionate to the amount of individuals or the district lines in regards of background and so on and so forth. Now, only one district in regards of North Carolina in this map was a majority minority district. In other words, there were much more African Americans or Latino Americans in said district as opposed to Caucasians or white individuals in this area. Only one district, right? Now, the U.S. Department of Justice, led by Attorney General Janet Reno. Now, Janet Reno is basically the lawyer for the United States, right? That's all this happens to be. The lawyer for the United States. Rejected North Carolina's district plan. Okay. So U.S. Department of Justice, led by Attorney General Janet Reno, rejected North Carolina's district plan as we know it, instructing the state assembly to add another majority minority district in order to comply with the recent amendments that was set in place by the Voting Rights Act itself. Now, the interesting concept is this, is that while the United States Department of Justice mandated North Carolina to do this, they didn't tell North Carolina how to draw it up, right? That's a state concept. They didn't tell them how to draw up the lines in regards of it. They just said, just do it, right? Be like Nike and just do it. So North Carolina Assembly felt the pressure to make this happen, right? So now, instead of having just one majority minority led district, we're going to have two, right? Now, this is Janet Reno. Unfortunately, she passed away a few years ago, a couple years ago, excuse me. But she is extremely relevant in this case because she is the one in which her name is attached to this Supreme Court case and took it to the Supreme Court to sue North Carolina and its Secretary of State itself. So the historical background continues when North Carolina redrew the districts, proposing a second majority minority district, which was called District 12. This District 12 was oddly shaped, weirdly constructed, and it was following along a highway for nearly the entire length of the state. So let me break it down to you this way. It was almost like a sliver, right? It was almost like a tail, a tail of some form of animal, right? Alligator tail. Let's go with that one, right? We're in Louisiana. We can deal with that. And it kind of wrapped around a couple of districts itself to show that this particular district itself is a majority minority district. It was this oddly shaped. It wasn't like you was like a box or a circle or some way, shape, or form where it was very evident and clear and effervescent. This is the district. It cut through cities and towns. It was very purposefully done, and quite hastily done as well, right? So after the General Assembly passed the legislation creating the second district, because at least on state constitution, the General Assembly or the state Congress people had to pass legislation to make this happen. It had to go through state measures. And through the state measures itself, it created a second district, a group of white voters in North Carolina led by Ruth O. Shaw, sued on the grounds that the district was an unconstitutional gerrymander. Right now, initially, the original concept came toward the state secretary, the Secretary of State, excuse me. Then a group of white voters, like this state here, Ruth Shaw, stepped in and said, "Look, this right here is unconstitutional. The way it is shaped, right? The concept of it, the district itself was just plain unconstitutional. Going to create another district just because um, um, Attorney General Reno said so. It's just plain unconstitutional. There's no need for it. We already have a minority majority based district." Shaw's group claimed that drawing districts based on race violated the Equal Protection Clause of the 14th Amendment. In other words, by creating this new district, by establishing this new district, it's simply just giving another district or creating another district solely based upon the perspective of race. It's fundamentally wrong. You're also violating the rights and equal protection clause of white people at this time as well. So now Shaw is taking the mantle for North Carolina, and now we're going to have a clash between Shaw and Reno, hence the Reno and Shaw Supreme Court case itself. Now, this is important. If you notice on this map, the dark brown areas here on the far right is a majority minority district. That district was set forth by the state, and this is, interestingly enough, what part of the situation is all about, right? If you notice that this large dark brown area here is cutting through certain areas within other areas of the district and centering itself around African Americans and Latinos. But just the same, if you notice this little pink area right in the middle, this little sliver, if you will, right in the middle of North Carolina, is the other district, the district which it was formulated from scratch to represent a majority minority district. All right. So this particular district, District 1, which is the dark brown, District 12, the sliver of pink right in the middle, are majority minority districts. And if you notice, this particular district, District 12, the pink, actually cuts through 5 different districts within North Carolina. It cuts within the red area, which is District 2. It cuts within the light orange, tannish district, which is District 3. It cuts within the light green district, which is District 6. It cuts in the blue district, District 10. And the little teal right next to the dark green on the left, it cuts within District 9. So it cuts in all these districts here to set forth another majority minority districts. And Shaw is suing the Attorney General because of this now, taking the mantle for the Secretary of State and now suing them because this secondary district, District 12, is uncalled for and not needed. Now, the constitutional question and issue at hand in regards of Shaw versus Reno are as follows. One, the constitutional question is this: did North Carolina residents claim that the 1990 redistricting plan discriminating on the basis of race raise a valid constitutional issue under the 14th Amendment? Right? So, in other words, the residents of North Carolina state that the redistricting plan of 1990 was a blatant concept to discriminate on the basis of race. Now, many of these districts claim some minority members, right, within certain people to say they are diverse, even though it is an overwhelming majority of white, mostly Republican-led districts overall. So they're arguing this concept itself. Just the concept itself of redistricting itself violated the people of North Carolina 14th Amendment. But the issue at hand is that whether the General Assembly's reapportionment was done properly. So the issue itself also deals with how North Carolina redistricted and reappropriated itself to based upon the standards set forth by Janet Reno and the Attorney General of the United States. This is a very important argument that is being made here, because arguing that this district was so irregular compared to the rest that it could possibly be right that the district had a fair majority. So even if the district looks so wonky and so different and so out of shape, if you will, is that the issue? Or is the issue itself just creating another district that's a majority minority led district? It's a fundamentally flawed concept. So these issues are extremely important to answer along the way in regards to it, right? But not just that, keep in mind about the decision and the explanation that this particular decision actually holds. So, in the perspective that this happens, we have to look at how the Supreme Court justices view this. All right. So, now, let's get directly into it. So, here's the first concept. So, one, did North Carolina residents claim that the 1990 district plan discriminated on the basis of race raised a valid constitutional issue? They said yes, right? So keep in mind the state of North Carolina, reapportioned its district to the fact that the majority of districts, really at the time 10 of these districts set itself up to the point where the majority of people were not only white, but Republican led. And that alone drowned out the voices of African Americans and Latinos living in many of those particular areas itself. Also, a portion of this in regards of since you want to since that's the case, keep in mind that one particular district actually cuts into North Carolina Central University. We talked about this before. The perspective that that North Carolina cut in half North Carolina Central, and because they cut in half North Carolina Central, that it drowned out a portion of students living in North Carolina and drown out the voices and the votes of those African American and Latino students representing an HBCU. Now, on top of that, it was a 5-4 decision that the court agreed that the shape of the proposed district was so odd that there was no compelling explanation for its shape other than separating voters by race. Now, the 5 Supreme Court justices that agreed with this perspective was Rehnquist, O'Connor, Justice Scalia, Justice Kennedy, and Justice Thomas. That ironically, it specifically cut away a large proportion of African Americans, and that cut away of a large African Americans, that the district that was formulated for District 12 was shaped to the point where it loudly, even though it was indiscriminate, it loudly showed that it separated African Americans itself from the population. That the shape could not even be, I guess the best way to look at it, could be argued or couldn't be backed up with the purpose of why it was cut this way. Because it was purposefully done, hastily done. So that harmed the argument set forth by um, by Shaw, it's by Reno, excuse me, itself. But not just that. Although district plans may take racial considerations into account, right? So when you're cutting or reapportioning a district, it's also important to take into account the perspective that race also has some type of deal when you're reapportioning districts. We talked about the district for from Representative Richmond, who's based out of New Orleans. His district is cut so oddly that it cuts around other areas and other towns and other cities and nestles itself around the majority of African Americans and Latino communities overall. In this case, in regards of North Carolina, they're saying overall, at least the Supreme Court justices are saying, we get the fact that district plans can take and normally would take racial considerations into account, so African Americans and Latinos and other minorities are able to have their voice heard effectively and efficiently, specifically in state matters. It also must meet the provisions of the Voting Rights Act itself, and race cannot be the predominant factor in drawing districts. In other words, North Carolina can't set up a district solely based on African Americans, Latinos. They must take in other accounts. They must take in the concept of economy. They must take in the concept of possibly even religious factors, if that's the case. They must take in the factors of population density. So all these concepts must come into play along with the perspective of racial considerations. That racial redistricting must be held to a standard of strict scrutiny. In other words, if you're going to specifically cut out a portion of a district that is blatantly set forth based upon minorities, African Americans, Latino, Asian Americans, so on and so forth, then that particular district must be scrutinized to the nth degree. And to figure out, is said district solely based upon the concept of race? And if so, what can be done to solve the problem, even if you have to disband this district and possibly reshape it in a different manner? It also states that meaning that any law that results in classification by race must be first have a compelling government interest. In other words, you must explain in detail why it is important to have a blatantly and not so indiscriminately cut out district solely based upon racial factors. Remember, it has to be solely based on racial factors. But not just that, be narrowly tailored to meet that goal. So the goal itself must be narrow set to the point that this racial district is vital for some form, fashion, or way for the voice of these minorities to be heard loudly, if not more loud than their white counterparts. And also be the least restrictive means for measuring and achieving that interest. In other words, it has to be the most restrictive concept to achieve this interest. It must be very blatant to the point that the voice of these minorities, men, women, and children, are heard loudly and without any type of muzzle set forth by the state, whether it's in North Carolina or any other state of that nature. So the majority decision, the five Supreme Court justices, their particular decision, remember the five Supreme Court justices that agreed with this concept, right? With Rehnquist, O'Connor, Scalia, Kennedy, and Thomas. They specifically state that, in particular for Sandra Day O'Connor, who delivered the 5-4 decision, it's herself, on behalf of the other four Supreme Court justices. Legislation that classifies a person or group of people solely based on their race is by nature a threat to the system that strives to achieve equality and majority opinion. In other words, if you purposely set forth a racial agenda, it not only hurts that particular race and group of races, it actually harms the entire community, the entire state, and even so, the entire nation. Also, Justice O'Connor states and noted that there are some rare circumstances, very rare by the way, where a law can appear racially neutral but cannot be explained through anything but a race. So maybe the intention of it was warranted, right? Maybe the perspective of creating this district was needed to balance out the one-sidedness set forth by North Carolina. However, that neutrality just can't be explained through anything but race. In other words, the explanation as to why this district was formulated is only solely because of race, even though you're trying to be neutral about racial discrimination, when you're trying to be neutral in regards of racial classification. North Carolina's reapportionment plan fell into this category, where you purposely set forth an agenda to separate African Americans and Latinos from the others so they can have their own voice in the state legislature. It was so blatantly done that while you're trying to neutralize it, there's no other way to classify it as the concept of it harms the 14th Amendment to the state itself in regards of the rights of the people. You cannot create just a district solely on racial class, even though you're trying to remain neutral and you're trying to have more voices heard in a district. Other factors must come into play. Also, keep in mind here that Justice O'Connor, on behalf of the majority, found that redistricting plans could take race into account in order to comply with the Voting Rights Act of 65. So you can take race in when you are dividing up and reapportioning a state, but race could not be the sole or predominant factor when drawing out a district. Remember, I said this earlier, right? There are other ways to reapportion the state outside of just racial considerations, economic considerations, um, population density is another example where you're able to divide up an area of the state appropriately. So there's so many other factors you can go into. You can't consider race, but race can't be your sole focus. She specifically stated, and this is one of the most important quotes within hers, I think it's a 6 to 7 page um, summary, a summarization of why they came to be with this particular case, is that it reinforces racial stereotypes and threatens to undermine our system of representative democracy, specifically by signaling to elected officials that they represent a particular racial group rather than the constituency as a whole. In other words, we have a representative that solely represents the black and brown community, not the overall constituency. So you can't have the voice of the voiceless be the individual to only represent minority groups. He or she must be able to represent not just the minority groups, but just people in general. And the people in general may just so happen to be majority minority, but there are also individuals in there that aren't minority members, but live within a particular economic group, in a social group, in a specific social group, um, in a specific religious area. All these things must come into play when you are looking at a reapportionment of a state. Now, the dissenting opinions, right? The dissenting opinions in Reno versus Shaw. Now, in his dissent, Justice White argued that the court had ignored the importance of showing cognizable harm, also known as proof that any sort of harm had even occurred. So, Justice White is speaking on behalf of Justice Blackmun, Justice Stevens, and Justice Souter, that saying that you must be able to show this harm and have proof that the harm itself even occurred to the people in that district. He said in order for white voters in North Carolina to even file this suit against the state and the federal government, they, that particular people, those particular individuals, those individuals that set suit against Janet Reno must show that they too have been harmed irreparably. In other words, the white North Carolina voters could not show that they were disenfranchised as a result of the second oddly shaped majority minority district. So Justice White with Justice Blackmun, with Justice Stevens, with Justice Souter clearly tells you right now that the individual who filed suit, as well as the white individuals who has their name on this piece of document, must explain and show beyond a reasonable doubt that one, they have been disenfranchised, two, they have been harmed irreparably, which harms their vote and their voice out loud, and three, that even with this oddly shaped, ridiculously looking district, that this particular district, or District 1, by the way, the large brown shaped district that you saw earlier, actually harms the rights and privileges of white folks in North Carolina. And no such word or proof or documentation shows this. Now, their individual voting rights had not been impacted. Justice White is telling you all the all the Caucasian and white folks, pardon the pun, their rights haven't been impacted. Their voice haven't been drowned because of these oddly shaped districts. Justice White argued that even the drawing districts, the new draw districts, based on race, in order to increase minority representation, could serve an important government interest. So let me put it to you this way. They're specifically telling you that at least the four justices are specifically telling you that even with these oddly shaped districts overall, that representation for minorities is a good thing because now they can increase their level of participation in the concept of government. This is equally important. You can't just drown out the voices of African Americans, Latino people, yet and still you want them to still be a part of the governmental system. We have to include them, even if it means drawing a state district that is oddly shaped and predicated primarily on African American and Latino involvement in government. Also, dissents from Justice Blackmun and Stevens echoed Justice White. In other words, they say they agree with Justice White specifically that the Equal Protection Clause can only be used to protect those who have been discriminated against in the past, which we know that the laws that were set forth by the state as well as by America, to a certain extent, did not allow African Americans to fully participate in the political process. They realized that African Americans had to pay poll taxes and pass literacy tests, and white folks specifically in the South found ways to harm the black voices in America, whether it's on a short-term basis or a long-term basis. They still found ways. And that within itself was harmful. So you had to find extraordinary extraordinary way to enhance the voice and perspective of the black people. Also keep in mind that white voters could not fall into this category because they was never discriminated against. By ruling in this manner, the court actively overturned a past ruling on the applicable standard of the equal protection of the law. In other words, this gutted a certain portion of the 14th Amendment because African Americans, at least by the four Supreme Court justices that voted in favor of Reno, remember, it's Justice White, Justice Blackmun, Justice Stevens, and Justice Souter, specifically tells you that white folks were never discriminated against in history, that black folks were discriminated against, and laws were set to purposely drown out the power they had in the community, in the state, and so on and so forth. And that an extreme amount of detail must be taken and work must be taken to enhance the voting rights, to enhance the voices of minorities, which in the South, the voices and the participation was was very low, and in certain areas next to nothing. All right, and even to a certain extent, you can't state that just because a small percentage of African Americans who came out of abject poverty and harm picked themselves up by the bootstraps and worked their butts off doesn't mean that everybody else who African American have those standards and have those particular the opportunities that other African Americans have. So you must be able to figure out inventive ways and ingenious ways to enhance the voices of African Americans and minorities. Now the ramifications of this case are pretty clear. This had a major effect on the U.S. because it set more of a colorblind approach on who government officials are represented by proving that black can't only be represented by black representatives. As we see in today's society with a black president, which we had before, that whites can't only be represented by white officials. In other words, in this particular case itself, in this perspective alone, that even though we've had an African American president who represents America or represented America, it is important to fully understand as well that within this case itself, whites can represent African Americans fully and well. However, you must be able to have the voice of the African Americans in the ear and the mindset of their representative. White, black, Asian, doesn't matter. Even Hispanic, doesn't matter at all. They must be able to represent themselves well. And you can't drown their voices out just because you could. It also sought to undo racial cooperation by saying that if racial separation and favoring were to continue, then our country could become more divided in terms of government. In other words, what the Supreme Court justices are saying is that you can't solely base everything on race itself. And by doing this, you're going to divide the country up even more so by subjugating some sort of majority minority district lines. It will cause irreparable harm to all people involved. Now, whether you believe in this concept or not is irrelevant to the fact. It's important to understand that these are ramifications of the case. In other words, you can have individuals represent other individuals no matter the actual race they may be, religion they may be, social class, economic standard, or so on and so forth. But it is extremely important to note that African American voices must be heard, and even with majority minority districts, you must have a strong voice to represent the strongest voice of them all, which are minority individuals. But this case also allows the state to purport to reapportion the state itself in any which way, shape, form, or fashion that it decides and it can base off of this. Remember, all states have some form of districts that's oddly shaped that are led by majority minority individuals. It is not just North Carolina, South Carolina, Louisiana, Mississippi, Texas, Alabama, Florida, Tennessee, Virginia. You have other areas within Illinois. If there's a majority a minority, you still have slivers within those particular districts itself. Minnesota, they all have some form, shape, way, or fashion that shows a majority minority led district. That the shape is just weirdly constructed. All right. With that in mind, we end the case in regards of Reno versus Shaw. So keep in mind what we talked about before, right? The perspective that Reno, Janet Reno, the district attorney for the United States, set forth a plan to North Carolina to create another majority minority district in North Carolina because too many African Americans and minority people voices were drowned out. But not just that, while not going back and forth with the state secretary of North Carolina, white members of North Carolina sued Janet Reno because they felt that their 14th Amendment was violated. Also, keep in mind that that the 12th district, which we just talked about here, the 12th district, this pink area right in the middle, was set forth on the request of Janet Reno, and that Ruth Shaw sued Reno because it violated the rights of herself and other white individuals in North Carolina. And based upon that, did this new district show a distinct bias and violated the 14th Amendment, the Equal Protection Clause, against white folks in North Carolina? And ironically, in a 5-4 decision, the court agreed that it did. And remember the 5 court justices that believed that the rights of white people in North Carolina was violated because of this minority majority district. These 5 justices were Justice Rehnquist, Justice O'Connor, Justice Scalia, Justice Kennedy, and Justice Thomas. While the 4 justices who believed that the district itself did not violate the 14th Amendment and the Equal Protection Clause within that amendment, those 4 justices were Justice White, Justice Blackmun, Stevens, and Justice Souter, believed that the 14th Amendment was actually enhanced because we were able to find another district to where majority minority individuals were able to have a voice to their concerns. And it led to so many other states throughout the United States, specifically have oddly shaped districts in the state and able to effectively separate these districts to the point where it's evident that it's a majority minority district and still be able to have their voices heard overall. And that it's fine to do so, but it can't be so indiscriminate. It can't be to the point where it's so loudly based. This is the case, right? You must have other factors to represent this perspective. Remember, it's not just about a racial class. It's about social conditions, economic conditions, even religious conditions. So many other conditions that must be involved in this case as well. All right. So with that in mind, that ends the concept of Reno versus Shaw. As I said with other cases, I'll provide information in regards of this case. I will also provide summaries for you to look at and enrichment exercises for you to go through to have a better understanding of Reno versus Shaw. We'll continue on the concept with our next case, and I'll provide that information for you very soon. Again, please stay safe, stay healthy, be blessed, be well. If you need anything at all, please email me. You have my email. I will respond to you as soon as I can. All right. I'll talk to every one of you later on. Take care. Be blessed. Talk to you later.